Okay. Hello, I'm Rick Steele, and I serve as the chair of the Licensed Psychology Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic media. Jonna Norton, Bruce Nystrom, Abby Callis, Carol Crane.
Here.
Hey. Jessica Hamilton.
Here.
Tiffany Johnson.
Here.
Janine Kesterson. Rodney McNeil.
Here.
Zachary Parrott.
Here.
Doug Wright. Okay. I note the following staff members are also present: David Fye.
Here.
And Leslie Allen.
Here.
Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or COMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at the meeting today, as no individuals requested to provide public comment. Because we are conducting this meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by a medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the COMA are not suspended, so we'll be conducting this meeting pursuant to the COMA. On April 22nd, 2022, we sent notice of the advisory committee meeting to all individuals who requested notice of advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials will be posted on the board's website on the day of the meeting, and those have been posted. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line "request for the agenda," and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240, or since we are after hours at this point, it's not recommended to go ahead and send an email to bsrb@ks.gov for our documentation purposes. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And the conference call is currently active too, so if I hear any beeps or anyone enters the conference call, I will let you know.
Thank you, David. The meeting is now called to order, and the advisory committee will begin its discussion of the first item on its agenda, which is the approval of the agenda. I believe you all received that via email on Monday. Do I have a motion to approve the agenda? Thank you, Jessica.
This is Jess. I'll approve the agenda.
Thank you. Do I have a second?
A second.
Thank you, Rodney. The agenda is approved, and the next item is minutes approval for our meeting from April 12th, 2022. And those were also sent out to the advisory committee yesterday in that email. Hopefully you had a chance to look at those. And if you got the chance to look at those, I would entertain a motion to approve the minutes, or if there's any corrections that people would like to request.
I can go ahead and approve the minutes.
Okay, we have a motion to approve.
A second.
Thank you. And all in favor of approving the minutes, please indicate that.
Aye.
Aye.
Aye. Great. And so that gets us to number 4, and that's David's Executive Director's report.
Thank you, Rick. So first one item about the agency, we are still under a lot of the governor's direction related to the pandemic, including the restriction on in-person meetings. And so meetings will continue to be held virtually. We have inquired if there's been any changes to that policy, and it remains in place. So we will let you know when that changes, and we'll be able to resume the option of meeting in person again. In terms of another item related to the BSRB, every staff member for the BSRB has an annual performance review. And as part of that process, the Department of Administration asked us to meet with all staff at the beginning of the year and then to do a mid-year check-in, and then to meet with all staff for the formal performance review at the end of the year. So this month, at the end of the month, we will be meeting with all staff members for the BSRB and providing them feedback so far on their performance and reevaluating their position descriptions and allowing them the opportunity to ask any questions in that regard. So that will be happening for us at the end of this month. Some updates from the board meeting on May 9th, 2022. The advisory committees begin to report back their preference on whether they would like to have pre-approval for continuing education classes or pre-approval for continuing education providers. Previously, the BSRB had put in a policy for the social work profession because that profession had requested the ability to have pre-approval from the BSRB, but that is the only profession that currently has that. So the board asked advisory committees to discuss that and start reporting that back. That started at the May 9th meeting. Advisory committees were split on their preference for that, but some of those report backs are expected to continue at the next board meeting in July. Additionally, advisory committee members began to be reappointed to their new terms. At the May meeting, 15 advisory committee members were reappointed to a new 2-year term, which begins in July. We operate based on the state fiscal year, which goes from July 1st through June 30th. So there's some additional advisory committees that are still discussing membership, and there will probably be some additional recommendations and motions for new committee members here in the next, at least in the next meeting in July, or possibly the following board meeting after that. 3 advisory committee members were recognized at the board meeting as having served the maximum length of service at the advisory committee level. Advisory committee members can serve up to 4 2-year terms, and so they can serve at most 8 years on the advisory committee. At the last board meeting, Joyce Baptiste and Rebecca Culver-Turner had served 8 years on the Marriage and Family Therapy Advisory Committee, and Kenton Olaf had served 8 years on the Professional Counselor Advisory Committee. So we thanked them for their years of service on those advisory committees. There was a delegation motion passed by the board to allow for alternate presiding officers in the event that the chair and vice chair may be unavailable to preside over certain board activities. There was also some language that was officially reviewed by the board concerning some actions the board had already voted on in the past. A couple of these were some specific language involving fees for board-approved supervisors, for professional counselors, and marriage and family therapy. There was also the specific language on the SciPAC home state fee for licensed psychologists who are participating in SciPAC. And then there was also some changes that were recommended by the master's level psychology profession and the marriage and family therapy profession as well. There was an item that was discussed at a previous board meeting as it relates to the social work profession. There are currently new programs that are starting that are seeking to gain accreditation by the Council of Social Work Education, that is CSWE. And CSWE is the national accrediting body for social work. Their accreditation process can take several years for some of those programs. And so there are certain graduates from those programs that graduate while the program is in a process called candidacy for accreditation. And that is occurring here in the state of Kansas. And the board recently met to discuss how to deal with those graduates who are graduating from the programs that are in candidacy for accreditation. Specifically to the social work profession, one of the reasons that that comes into play is because when you look at our statutes and regulations, there is a path for licensure that says, did you receive your education from a school that is accredited by the national accrediting body? And if you didn't, there's a separate set of standards that are in regulation that have to be met. And for the social work profession and some of the other professions, there has been an in-resident requirement mandating that about half of their education had to be received while the student was physically at the school. And so for some of these new programs that are starting out, some of these are online only programs. And so they would be unable to meet those qualifications and regulations. And so the board is discussing basically what to do with the in-residence requirement, if that should stay in place, if that should be changed. The advisory committees for the different professions are discussing that, but specifically about those graduates from the programs that are in candidacy for accreditation. Some information was presented to the board at the May 9th meeting. That was a model currently being used by Minnesota, which allows graduates from programs that are in candidacy for accreditation to receive a temporary license from the board in Minnesota. And those individuals can practice under the temporary license. And then should the schools reach a full accreditation, then those individuals would have the opportunity to go ahead and apply for a permanent license at that point. If it's a year-long temporary license, and if the program is still seeking accreditation by the end of that year, it cannot be renewed, but the board can extend that for another length of time. And so that is one model that the board reviewed. I expect the board later on this year to consider that and possibly other options in terms of those students graduating from those programs. There is also currently an investigation policy that is used by the board when evaluating complaints against practitioners. That is a process that aids the work of the Complaint Review Committee, which is a subset of the board who then investigates those types of complaints. The investigation policy is in need of some updating, and so I provided a report to the board with some changes for consideration, and those were also run by legal counsel for the board and also the investigators for the board for their thoughts and their comments. And so the board is reviewing those, and the board may take action on some of those possible changes at the next board meeting in July. Additionally, two advisory committees sought board approval for subcommittees. And so under the statutes for the board, for board members to receive payment for attending meetings of the board or subcommittees of the board, those have to be approved by the board. So two of the subcommittees that were requested include one from the professional counselor profession, and that was a subcommittee to specifically evaluate the unprofessional conduct regulations, and the board approved for that subcommittee to begin to meet. The other subcommittee was for the marriage and family therapy subcommittee, and that was to focus on creation of a clinical supervision manual for the marriage and family therapy profession, similar to a clinical supervision manual that currently exists for social workers. Moving on to some other topics, an update as we are at the end of the fiscal year. So the BSRB currently operates on a fee-funded budget. We do not receive any money directly from the state general fund, but we run it on a balance. We obtain money from revenue from licensure fees, and we make expenditures. The beginning balance at the beginning of 2022 was about $2,077,000. The current balance in the fund is about $2,035,000. So we are running at a little bit of a deficit, but that is by design when the board lowered licensure fees back in 2019. So we are not in danger of needing to raise fees in the immediate future, but we will keep you updated on that. Revenue did fluctuate month to month by a pretty wide margin, and part of that had to do with some of the dates that some of the licenses were scheduled for renewal. But we will keep an eye on that going forward as it relates to the operations of the agency.
Can I ask a question related to that? Sorry.
Sure, go ahead.
Do we expect SIPACT licensing to impact the revenue stream moving forward? And when do we as a board need to consider making recommendations related to that?
That is a good question. And I do expect there to be some impact by SIPACT. So all licensed psychologists are required to renew in June or by the end of June in even numbered years, which we are currently in. So what we have done is we've gone ahead and run a report of all the individuals who have held a license currently for licensed psychology. And we also have the location of those individuals in terms of under SIPACT, you have to maintain a licensed psychology license in your home state. And so we have that report for before the renewal deadline, and we're going to be running a report after the renewal deadline and checking to see what sort of drop off we have from individuals who live out of state who currently have a BSRB license, to see how many of those individuals renewed their license and then how many of those did not. There's always going to be some drop off as we add new licensees and then some drop off, but we will be looking for that. And also I will be comparing to the SIPAC membership, which can be found on the SIPAC website, to see maybe how many of those individuals who dropped off are participating in SIPAC, to try to gauge the impact. And so I think sometime in July, we'll have a better idea of revenue loss due to SIPAC, but right now we're about a month away from probably having those totals.
David, is there a number that we have for people who just, as a function of every cycle, retire and just elect not to maintain their license?
We do not have historic totals on that. We have licensure totals going back several years. I think at least as far back as 2018, and it's been pretty consistent. But we don't really have statistics in terms of the average drop-off rate per year.
Yeah, because I think that would affect the data that you're talking about, because there would be a normal delta that I think would be built in no matter what.
Mm-hmm. Yeah, and for individuals that are living in Kansas, we don't expect there to be very much change because they would still have, even if they wanted to participate in SIPAC, they would have to make sure that their home state license is still active. And so most of those individuals, you do have a choice. If you have a license in more than one state, you can choose what your home state is. But under the SIPAC authority, you are only, let's say that you go ahead and seek approval to practice teletherapy under SIPAC. According to SIPAC, you name your home state, and then if you're practicing under that authority, you must be in your home state while providing that telehealth service. And so you have to be physically present in your home state while providing that service. So for those that are currently living in Kansas, we don't expect there to be much of a drop off. For the ones that are living in other states, that'll be the real group that we'll be looking at. Some other updates. I recently attended a mid-year meeting by the Association of State and Provincial Psychology Boards, ASPPB. That was a very interesting meeting. They covered a lot of really good topics. One of the main updates they provided and discussed at that meeting is that the APA is going to be seeking to establish standards for the accreditation of Masters of Psychology programs. And so master's level psychologists, they expect there to be standards available for that level of profession, maybe sometime in the fall of next year. They said that that is still tentative and it could take longer, but they went ahead and discussed that a little bit, that there has been a push for that and they are working on establishing some of those standards. And so that is something that is currently being worked on. There was a lot of conversation on the topic of, they called it overcoming barriers to licensure, and a lot of creative solutions that states are coming up with. Some of these are eliminating current licensure requirements. Some were temporary measures related to the pandemic. Some were targeting specific groups of individuals. They discussed military members, military spouses, and license portability. They discussed the topics such as cost, if there's a cost factor that might prohibit individuals from applying for licensure. They looked at what licensing boards currently look at in terms of things like a good moral character, or whether they meet certain standards in regards to past convictions. So there's a lot of these topics that are being looked at by different states to determine if they are still essential to be evaluated when determining if someone is eligible for licensure. And so there's a lot of good discussion about that. There was a discussion about deregulation as a topic itself. And then there was a conversation about SIPAC and some of the information that we've talked about this past year as it relates to the formation of SIPAC and potentially the future of SIPAC. And then I also attended another meeting. It was an open meeting where representatives from ASPPB were discussing the EPPP2 in further detail, and they opened it up for a Q&A at the end of that conversation. How they started that meeting was they walked through how the EPPP2 began, when they started developing that, and then they provided an update. I asked a question and I thought it would be relevant to know, are there any plans to make the EPPP2 mandatory in any additional jurisdictions? Right now, it is an optional exam for different jurisdictions. And I believe there's just a handful that have actually chosen to adopt the EPPP2. They basically said that they are collecting information now, trying to assess how to approach that in the future. There are no current plans to make the EPPP2 mandatory, but that is something that they are discussing to try to figure out the direction of the EPPP2 going forward. So I want to make you aware of that meeting as well. So with that, I will go ahead and end my report, and I can stand for any questions on those topics.
Any questions? Okay, then I suppose we can move on to old business. And the first item under old business is an update on SIPAC, the SIPAC Commission. David, have you got an update for us?
Sure. And actually, I attended a SIPAC training earlier this morning. Last year, the board named me as every state has a commissioner named to represent the state at SIPAC meetings. And so there was a meeting today that basically walked through some of the resources that are available as it relates to SIPAC. And so most of the information is publicly available. We have information posted on the board's website that allows individuals to click a link to a verification portal where they can look up a specific practitioner to see if that person is currently authorized to practice under SIPAC. You can also use that portal to look to see how many current individuals who list Kansas as their home state practice under SIPAC authority. And currently there are 50 licensed psychologists who are practicing telehealth under SIPAC authority. And then SIPAC also has a less popular temporary authorization to do in-state services in compact states. There are 4 licensed psychologists in Kansas that name Kansas as their home state who are practicing under that authority. So that has been increasing steadily every month, and I'll keep you updated on those current trends. There are 32 states and the District of Columbia that have enacted legislation authorizing SIPAC. 4 of those states have passed the bill, but it hasn't become effective yet. So there is the majority of states that have passed and are now members of SIPAC, and I expect that trend to continue. As I mentioned earlier during my report, all licensed psychologists in Kansas renew an even number of years. When we were becoming a member of SIPAC, I did consult with several other states to try to get an idea of what amount of licensure loss they experienced as a result of SIPAC. And no one really had any kind of numbers or had weighed that for their states. So I really don't know what to expect exactly, but I will keep you updated when I have more information on that. We've gone ahead and run the reports, so we have the data ahead of time. We will compare that to the data after the time. There will be a little bit of discrepancy because some of the individuals who apply for renewal are going to be pulled for audit. So their renewals are not going to be processed until those audits are fully processed, and all that is, that can take a little bit of time to make sure that those are squared away, but that's a small group of individuals. So I hope to have some better data in terms of the change in number of licensees, and then also how that could affect revenue, probably sometime in July.
Thanks, David. Any questions regarding the SIPAC Commission meeting? Okay, so the other old business where we'll get into hopefully some good discussion is continued discussion on unprofessional conduct regulations. You'll recall that last time we met, we walked through the documentation regulation, as well as, I believe, items A through E of the unprofessional conduct regulation. That's at least where my notes kind of end. And that seems to be consistent with the minutes. So I think we got through E. And so couple of just reminders. We looked at unprofessional, the issues regarding documentation, and one of the questions that came up was why that was pulled out as a separate regulation and not included under unprofessional conduct initially. David did a little bit of digging for us and found some previous versions of that regulation that he sent along with the other materials yesterday. And so I don't know, David, if you had other comments about that.
Yeah, just one. There was a request from advisory committee members to have past versions of the regulations in case they wanted to compare changes between the different versions. For the main unprofessional conduct regulation 102-1-10A, there were really only two versions. The first was put into place back in 2000 with an effective date of 2002. And then the second was put into place in 2002 with an effective date of 2004. And then, as you mentioned, there was the separate record-keeping unprofessional conduct regulation 102-1-20. And I don't know why that was put into place as a separate regulation. It has not changed since it was initially put in. So I'm not sure why it was separate. I did contact the state library and also went to a portal on the Secretary of State's website to look to see, because I think there was also advisory committee members asked if they combined that into the same regulation, would there be an effect by other regulations that may be referencing the record keeping regulation. And from what I could tell, searching through that, I believe the only regulations that reference the record keeping regulation were that regulation itself, and then also the main unprofessional conduct regulation for the BSRB. So I think if you combine that, from what I can tell, I don't think it would cause any issues.
Okay, so one recommendation that we could make is to, and I think it would fall under the category of consolidating and simplifying things. If we decided as a group we wanted the record keeping to be subsumed underneath 102-1-10A, just for, again, simplicity's sake, so that we don't have licensees having to chase down multiple regulations. But that, we don't have to decide that right now.
And Rick, just as additional information, the Marriage and Family Therapy Advisory Committee met last month and made the same recommendation. They recommend to go ahead and combining those as well. So.
Okay. Well, I mean, it certainly could make sense. We might have to go back and look at 102-1-20 again if we do put it under unprofessional conduct, just to make sure then the language is directed towards what is unprofessional versus what is expected, right? Because if my memory serves, it's currently worded as what is expected. These are what should be included, and so it would just need to be negated, right? So unprofessional conduct includes record keeping that fails to do these things. So that would be easy for someone to do.
And Rick, there was one other item I wanted to provide an update on as well. I believe through some of the discussions, the term supervision was discussed in certain contexts, and supervisee, supervisor, and it was discussed on whether the term supervisee and supervisor would refer to a clinical relationship or whether it would refer to an employment relationship as well. I did reach out to legal counsel for the board, and it is the opinion that in most contexts, it should relate to the scope of practice as it relates to the clinical type relationship versus an employment type relationship. Now, if there was some additional language that was added that specified that it was an employment supervisor versus just a generic supervisor term, that might help out with delineating between the two. But I think absent any kind of clarifying language, it would probably be seen as something more under the scope of practice as it would relate to clinical supervisor, supervisee type language.
Okay. Very good. Okay, so One other thing to keep in mind is kind of something to keep running in the background is we've also been asked to consider assessment procedures as related to telehealth services, right? And we had decided to consider, rather than considering a separate, perhaps regulation regarding assessment procedures in a telehealth environment, to consider, and we should get to that tonight, I think, if we get to J tonight, that is improperly using assessment procedures. So we may need to just have a special note there about how to address electronic assessments and make sure that's addressed under J. So that's just putting it out there so that I don't forget when we get down there. So if we made it through E, unless there were other comments about A through E under the unprofessional conduct regulation, then we're ready for F, which is ignoring client welfare. And there are, looks like about 11 elements of paragraph F. David, would I call that paragraph F or section F?
I think section F is good.
Section F is good. Okay. And so ignoring client welfare, there's again, 11 ways that are identified where a psychologist could ignore client welfare that would be unprofessional. One of the things we talked about last week or last time was identifying a repository for client records should the psychologist become incapacitated. It's conceived, and we didn't make a specific recommendation about that, although I think there was general agreement that it's probably a good idea if all of us identified a repository of records. Whether it's ignoring client welfare, we could decide, but if my failure to identify a repository of records is ignoring client welfare, it would be relatively easy to list that as number 12 if we wanted to make that recommendation.
Just a quick question. Have we begun requiring the renewal of license to specify where we may have the repository, like where we store the records? Has that been enacted, or so that would answer, that would be related to your
right. So we've talked about that, but that is not, we have not changed, as far as I know, we have not changed the renewal process. Actually, I just renewed and it did not include that. So, so no, we have not done that yet, Carol.
Okay.
But that was one of the conversations that was going on about that, both with our group and with the board, is that it would be conceivable to just add an item to the renewal packet to say, please identify, who is the repository for your records should you become incapacitated or unable to access your records. That, in my, just personally, that seems pretty painless and reasonable, but no, that's not been done yet.
Now, part of that was we were looking to partner with the Attorney General's office, their consumer protection or protecting the public. They have a division that will seize records when they are in danger of someone else obtaining those records. But in a lot of situations where someone might pass away, but a spouse has custodianship of the records, they would not assist with the transfer of those records. And so as we moved closer to establishing a standard for making a requirement, there were some practical considerations for how that should take place. And we really had not been able to work through how to answer a lot of practitioners' questions for how to deal with custodianship and transfer of those records. And so that all came to a head right before the legislative session started, and we intended to circle back to that. And so we're examining that topic again right now, but it was more of, there was general support for doing something like this, but in actually figuring out the details of how to answer those practitioner questions, we just needed to have more thought, more discussion in terms of a process.
Makes sense. Thank you.
Do you know if there's any commercial organization that provides that? Because our conversations seem to assume it's a person that will have access to that information. But there are situations where I could assume where a person may not have, like a clinician may not have a particular person to identify. And that goes to the question of then of if there are places like that, are there standards for the care of those records?
I'm not aware of companies like that. They might exist, but I'm not familiar with those.
They see a new business venture.
Yeah, that seems, yeah, right. I've never, have you, I guess you've then not heard of anything like that.
Now, it seemed like they would want to move toward that model, much like I think we should move to that on a national level for continuing ed credits, that there would be a central depository of that information. And so it wouldn't be a question of playing Where's Waldo. When you needed that information, you would know you would go to this centralized depository to get that type of data.
Yeah, that seems like the trust, or some organization like that would be interested in that, having I'm just thinking about professional practice organizations that take care of private practitioners, right? So if you're affiliated with a hospital, it's not an issue, or the VA or a university training clinic or anything that exists.
Big. Yeah.
Right. But if you're a private practice, particularly, or a small group practice,
Where does that stuff go?
just know, yeah. Yeah. But just asking the question, I think the value of either, or maybe both, and including it as an unprofessional practice issue, or just having the question on the renewal form would prompt a psychologist to just think through that, right? So if I'm not really in private practice, and so it's not so much an issue for me. But until this was raised, when we first started talking about this topic, it really had not occurred to me to think through, well, who would get my.
Well, and we can take that one step further. I mean, if we use the same model of what we do for continuing education, some percentage of us are audited every so often to validate that has happened, because there's nothing to stop me to put something bogus into a line that says, or a checkbox that says, yes, I've got a central place to do this, and have nothing in place. I mean, that really has no meaning unless you can validate what the person is saying. I do agree with you. Sometimes just asking the question does prompt this kind of discussion.
Does it make, if we were to think about making a recommendation, does it make the most sense to put it in this section of client welfare, or would it make more sense to put it in perhaps a assumed record keeping?
I think it would make more sense under welfare, because it does directly affect patient care.
Is there harm to be listed in both? Like, because the intent, the spirit behind the intent of the regulation is slightly different?
I would defer to David on that question. What do you think?
I'm a bit torn. So the record keeping regulation 102-1-20, the majority of that is items that would be included in the records. But there is under section C, it talks about the retention of records. So there could be a piece under that that would essentially, you could put something in there that would require a practitioner to have a next custodian identified. And then if you wanted to potentially add that as an item 12, failing to have something like that set up, that would cover both bases, because under 20, it would be more instructional, I suppose. And then under 12, it would outline that it was a clear violation. So
that seems reasonable to me. What are some other thoughts? Particularly, if those of you, if you've got private practice kinds of issues. I know some of us are with VA or larger structures where this is not so much an issue, but for those who are in more private practice or small group, what are your thoughts? Let me throw out potential language for an item number 12 in this section. Failing to identify a repository for client records should the psychologist become incapacitated or unable to access client records. Would that be good for draft language?
could you repeat that, Rick?
Sure.
Okay.
I wrote it down because I knew someone would ask me to repeat that. And I'm notorious for not being able to do that. Failing to identify a repository for client records should the psychologist become incapacitated or unable to access their records. I don't, the after the or thing, I wasn't sure about. Because if I'm not incapacitated, there should not be a moment when I can't get to my records. But if I'm incapacitated, I'm incapacitated. So maybe there's no need for the or unable, but
I guess I'm thinking through, that's why I didn't comment earlier on the just process. And I'm thinking about the clinician who retires and then exits the state. They go to Florida, whatever. From the
or Croatia.
yeah, that's where I'm planning on going.
I mean, Croatia is a lovely place. Let me just tell you. Yeah.
So, I'm thinking about one clinician I've actually worked with recently who did just that, was working on the Missouri side and retired and then went to Colorado to hang out. In the process of retiring, they gave up their license. So, in terms of sanctioning people, is this going to have teeth?
Well, it only had
do it, but
right.
I wondered just from a process point.
Mm-hmm. Right. So it has teeth on as long as the person is licensed. So for me, right. So I've got my caseload, and while I'm active, I have a person identified. If, like you say, I have lied, if I've checked the box and said, yeah, sure, I'm going to have them in my safety deposit box at Central Bank of Lawrence.
Or under my bed.
Yeah. And then I just go ahead and retire and move to Croatia. Yeah, you can't really do anything about it. I don't know that there's a way around that, though.
No, I don't think
right.
So. I mean, just maybe putting something in place.
Mm-hmm.
Spirit of that hopefully will carry enough people to the point that they will do it. but I do think it's a practical issue. I can see why a person would give up their license at the end of their career. I mean, from a cost viewpoint and also from a legal liability viewpoint, although it doesn't stop you from being sued, as this individual, I think, found out that I'm speaking about.
Well, and there's another scenario that could be involved here too, and that would be, should someone abandon their license and their records, and then later in the future want to become licensed again, then there would be items that would need to be resolved, and that could be something that could be looked at when the board evaluates should their license be reinstated. So,
And so having it here, so I think to that point, having something in the unprofessional conduct would have teeth, right? for
Yeah,
that
be
person.
grounds for
Yeah.
like future renewal or reapplication, right? Mhm.
Okay, so are there any other, under ignoring client welfare, any other issues that you think need to be added, or any of the specific 11 existing items that no longer make sense? Because that was one of our charges, to review these to make sure they were all still applicable. And as a group, do we need to vote on whether we would like to recommend that 12th item? Or do we just put it in there, and then that's something the board would decide if it wants?
So ultimately, a list of recommendations could be forwarded to the board. If you want to go ahead and vote on that now, it could be something that could be forwarded to the board for consideration. So that would be appropriate for a vote.
Okay. Is there a motion to use the language that we had earlier, or additional or other language? Okay. Okay, well, we can just leave it in our minutes as something we considered, but did not vote on. All right, G is protecting client confidentiality. Well, it doesn't say client confidentiality. I suppose that's because it would also include, well, you would think it would include other kinds of confidentiality, but it is actually only client confidentiality, but protecting confidentiality.
And Rick, I've got to jump off to go to Taekwondo class with my son, but yeah. So I'm sorry that I have to leave early. I just wanted to make sure I signed off.
Okay. All right, thank you.
We still have a quorum to continue discussion.
So we are currently at quorum right now. If we lost one member, we would not have quorum, which means that the advisory committee would not be able to take any official action. So you could still have discussion, you just wouldn't be able to vote on any official action.
Okay.
Well, thank you so much for making me feel that much guiltier about Taekwondo.
We all have to take care of things. I had Taekwondo lessons for my kiddos at one point, so enjoy that. Okay. Then any general thoughts about failing to protect confidentiality? There is some note there under D. Let's see, where is it? It is 3A, right, noting electronically recording sessions. So failing to obtain written informed consent. So there is some telehealth mentioned in here.
I have a question on electronically recording sessions. Would that be telehealth, or I was thinking that would be something different?
Well, yeah, you're actually, well, it does say electronically recording, right? So I suppose that is different than telehealth.
As in, because we're communicating, we're not recording, there's no record.
That's true. Okay, so if we think, so thank you, Tiffany, for that. That is a good, very good point. This may be a place where we need to add something or update something to ensure that appropriate telehealth guidelines are being followed if services are being provided remotely. I suppose it could fall under number 1. So if I have informed each client, supervisee, or student of the limits of client confidentiality. That's more of a privacy though, actually, isn't it?
The act of recording?
No, the act of the possibility. So what I'm imagining is if I'm engaging in telehealth, there are limits, even if I'm using a HIPAA approved platform, there are limits that exist on the degree to which I personally can ensure confidentiality, right?
You're talking about transmission.
Yes, right. And so I'm wondering if under number 1, we might consider an additional letter A that would further specify failing to, in the telehealth environment. And don't ask me to repeat this, David, because I'm just throwing words out there for us to think about.
Do it.
In the in the telehealth environment, failing to inform each client the limits of, I don't know, what someone who does telehealth more than I do. What?
Well, I do a fair amount of it. And there is a part of my practice, particularly when we do court-ordered evaluations, that we purposely now have gone to a telehealth approach to it. It just was easier. We had to change with COVID, and we just stuck with it because Zoom provides me a method of recording the sessions. But in that case, it's kind of weird because the person who is under evaluation understands that they are not the client. We make a big to-do about that because we do court-ordered evaluations. The court becomes the client. But I have found that even when you tell people, it doesn't mean that we shouldn't be informing people of this, but even though you inform people over and over again, you can give them a piece of paper with it on it, they're oblivious or they don't care. Particularly the younger folks, they just don't care because they're so used to being in a video world.
Yeah, I can certainly appreciate that. That's true of the students as well, right? And right, so it's a both and situation. I have no doubt that that's accurate, and I also wonder if we still don't have an obligation to make sure they to do our part to make sure they understand the limits. Yeah.
Well, I think we do. I think
Yeah.
we do. But I've just kind of I've noticed that you could tell people all kinds of things, but it's like water going through a sieve, you know. Doesn't mean that it shouldn't be done, but because I spend a lot of time explaining that you are not my client right now, and I want people to understand that. And it happened today, you know, that poses limits to access to records. I'll have someone come back in months later and they'll ask me for something that I blatantly told them you will not be able to get. And it's as if nothing happened. So, you know, I want to stress, I still think it needs to happen. I do think it needs to happen.
The other thing that's interesting about this section G is it specifically notes failing to protect confidentiality, but it does not specifically note failing to protect privacy or respect privacy. And so our ethics guidelines, you know, of course, refer to privacy, autonomy, and confidentiality. And this notes only confidentiality, and the privacy issue is one of the things I think we're getting at privacy as much as we are confidentiality, right? So it's my, depending on my client, Rodney, it's my responsibility to protect their confidentiality. Independent of that, I'm also to protect their privacy. And that's that's one of the things that's at risk if I'm doing telehealth services poorly, right?
Correct.
Like, for example, over my cell phone, you know, in the subway, you know, or what, you know, I mean, there's a lot of, you know, so I'm wondering if this needs to be updated to more specifically consider privacy in addition to confidentiality.
Okay, so help me out here in brief.
Yeah.
Can you make a distinction between the confidentiality aspect and privacy? Like, what is the central difference between the two?
Yeah, sure. So once you share information with me, it is my job to keep it confidential, right? Whether you share it with me is a privacy issue, right? So if I'm, so for example, I used to do my weight-related treatment with the adolescents, right? So if I'm shopping at Hy-Vee and I happen to be on the ice cream aisle and I see that there's a family that I'm treating that's loading up on ice cream, right? And that's completely not in line with what their goals were for this week. I don't have access to that knowledge because they didn't give it to me, right? And so I'm not going to say, hey, I saw you on the ice cream aisle in Hy-Vee. What were you doing there? Right. Or if I'm working with and maybe people who work with addiction would see this differently. But if I'm at my favorite tavern and one of my clients walks in, they did not give me permission to monitor their whereabouts. Right. And so that's privacy. Right. And so it's not a confidentiality. It can become a confidentiality issue, but it's also a privacy issue, right? And so I'm not going to go dragging private information and take that away from them, right? But once I hold this information that I have, it's my responsibility to keep it confidential as well. So they're joined, but they're also there's multiple aspects of it, I suppose.
Yeah, I see this distinction.
And so the privacy issue there for me with electronic service delivery is if I am not adhering to the telehealth standards and I'm doing it in such a way that these people are sharing information that someone else is getting while I am getting it, they are losing even if I keep it confidential, they've lost their privacy, right? And so I have to protect both.
To the extent that you can.
To the extent that I can, absolutely. And acknowledging that there are limits, right? And so, yeah, good point, Carol.
To address that, I just want to make sure that we have a strong boundary of what we mean by privacy, because we, like my point, you know, we can only control so much about their privacy. So if they are in a full house and we still have to do a session, then
Right.
is it the onus of the psychologist to, hey, you you have to get out, like it, so I don't know how we can make sure in our language that we protect, our role to, and not impose it
Right.
overly onerous.
Yeah, and so I think just acknowledging that to the extent that we can control that, we do, right? So I'm not going to be doing telehealth upstairs where my kids are, right? So if I'm going to be doing this, I'm going to protect the privacy by making sure that I don't have people walking through here on the way to their, the laundry room is right over there. I'm not, if I'm going to be doing telehealth from down here, I need to do things to protect their privacy. If they decide to do telehealth on the subway, that's their decision, right? And I think just acknowledging that to the extent that I can control that on my side, just like if one of your clients wanted to bring their best friend to session with them,
That has actually happened.
yeah, no, I get it.
And I had to inform that this is not a social event,
Right.
I was thinking about some of the guiding guidelines I give people when we're about to do one of our telehealth interviews. And I make a point of saying, make sure that you find a place that you control, that you have privacy, because in this sense, I'm kind of going beyond, because I'm trying to think about, let's not have distractions. That's what I'm thinking about. But really, it's more about, knowing what kind of information is floating, where it's going. But in your case, for me, it would be making sure, like in my office, that when I'm doing telehealth, that my door is closed and this stuff is not filtering out all over the whole suite.
There's there's a commission working on new telehealth guidelines, right? And we have someone that's participating in that. David, am I correct on that?
I'm not sure. I know there are a lot of groups focusing on that topic right now, but I don't know a lot about that topic.
Okay.
Yeah, I believe APA,
Yeah, I know APA does. I thought there was something. I thought it was maybe it was the Board of Healing Arts was working on new standards for telehealth.
Well, there was a bill that was being floated this year. It was introduced in a committee, but it did not go anywhere.
Didn't make it. Okay.
And
That must be what I'm thinking of.
Yeah, that would have established some telehealth standards under the umbrella of telemedicine. And so, so that was out there, but it didn't, I don't believe it got a hearing, and it definitely didn't make it out of committee. So that was introduced, and there have been some legislative committees that have talked about the need for consistent telehealth standards. But I don't think there's any group actively working on that. I mean, there may be small groups that are proposing recommendations on that topic. I'm pretty sure of that. But in terms of a leader, I'm not sure about that.
So maybe it would be sufficient, because this would need to stay fairly broad then, right? Because we've touched on a lot of different issues. Maybe it would be sufficient under G, just to note something like in the telehealth environment, ensuring that patient or client confidentiality, privacy are maintained to the extent possible until there's some more specific telehealth regulations, right? So there's guidelines that we should all follow. But I don't believe we can put in a regulation that psychologists would adhere to the APA. That I believe is unlawful delegation of authority, if I understand my training.
Yes. So so words are just words to a certain extent. So we could borrow their language and use that to add it into our unprofessional conduct regulations. But I think formally adopting their standard is when you run into that unlawful delegation item.
I
It's a-
do.
Go ahead, Carol.
But oh, sorry. I appreciate your point about the why privacy was not even mentioned within the section. So I do. If we cannot vote, so never mind. But for future reference, maybe we should bring up that privacy ought to be considered here, especially when we're dealing with telehealth.
Yeah. Okay. So I'm going to include those as two different items to revisit at our next meeting under G, privacy and telehealth. And between now and the next time we meet, I think I have a copy of the APA Telehealth Guidelines. And so maybe I can send those, David, to you and ask you to distribute those to the committee. And then maybe we can boil some of the ideas down. It's a long document, and an appropriately long document. But if we could boil down to principles to consider.
And to circle back to your 3A, I think maybe it will be important while we are doing Zoom or whatever telehealth session to mention in the consent form whether the session will be recorded.
Okay, good point.
Yeah, and just as a reminder, I think these unprofessional conduct regulations were last updated in 2004. So in terms of a video recording, I do think probably what they had in mind was someone putting up a camera and doing video recording. Yeah.
Okay, any other confidentiality issues that you see right now? That's interesting that would be the one that we see some room for improvement on. And I do think this needs to remain, it will need to remain fairly broad, right? Because there's obviously things, I mean, we can also think about privacy issues as it relates to Facebook or other social media, right? So, are my clients, if my clients like my Facebook page or my LinkedIn page, that's obviously their decision, but what responsibility do I have? So yeah.
Yeah,
Things were simpler in 2002.
I was actually going to mention that with social media, like even if you're a part, I think I said this before, but if you're a part of a group, a Facebook group of clinicians that like to consult with one another, protecting confidentiality there, because sometimes people do post publicly.
Yeah. So it might be something as broad as failure to protect privacy and confidentiality in all electronic communications, including telehealth, social, the problem is you don't want to be so specific that, because it's going to change in 6 months, right? It's going to be something else. So failure to protect privacy and confidentiality in electronic communications might be broad enough, right? So then if I go posting something about my client to my Facebook group, that would be unprofessional because we said failure to protect in an electronic environment. So that may be it's fairly simple, but it may be broad enough to capture the rapidly evolving electronic environment that we find ourselves in.
Makes sense.
Okay, if there's no other things under under G, then we need to go to H, misrepresenting the services offered or provided. Okay, I'm not hearing anything on that one. It looks at nothing's occurring to me on these, and I don't want us to just look for things that are, you know.
I second the motion of moving along.
Moving along, we're going to move along. I is engaging in improprieties with respect to fees and billing statements, which shall include the following, and there's 4 listed. I would note that there do seem to be a number of complaints regarding billing. So if you ever are really bored and want to go look through what all the complaints are that are posted on the, there is a fair number that have been posted that deal with billing. So this is it's a short little section, but it has a potentially high impact. I'm remembering one that I saw that's posted. It's from when I teach the ethics class, I use some of those complaints that are posted that have SPOs on them for items to talk about during class. They're really, I think, helpful. There was one where services were exaggerated. So I guess that falls under 4, filing claims for services that were not rendered. But I'm remembering one that it was, so I guess that would fall under, well, it would fall under number 1, exploiting clients or payers with respect to, okay, that's covered. Okay, any other comments under I? Okay. J, improperly using assessment procedures, which shall include the following acts, and we have 1 through 7. So these were last updated in 2002, we said, and went into effect in 2004. I'm kind of impressed. It wasn't that long ago, but these, I'm happy with what was included here in 2002. So obviously we don't have an item that specifically addresses electronic assessments, right? And so that's been an issue, so I guess an item, So if I'm trying to administer a test electronically that can't validly be administered electronically, that is in fact improperly using an assessment procedure. But it's not specifically listed as one of the items below. And I don't know if that's a problem. So if I'm trying to do the, I don't know, hidden,
Well, for instance, the MOCA has been
right,
tested, and then we
Right.
can administer it
right,
remotely. So that would be
right. So that would be proper. That would be a proper use of that item or that assessment procedure.
complying with the regulation. Yes. Mhm.
Right. But if I try to do some, I'm trying to think of what an object assembly on a whisk via Zoom. Well, no, right? I mean, who in their right mind would try that? But it would be improper use of. And so there's not a 1 through 7 here that I think addresses that specifically more than the general J statement. J, the statement is improperly using assessment procedures. And so I'm just wondering if there needs to be an 8, using assessment instruments in ways that have not been validated.
I'm not sure what, well, let me see. I wouldn't say that, but number 2,
Yeah.
Failing to identify situations in which particular assessment techniques or norms may not be applicable or failing to make adjustments. I'm not saying that covers the electronic registration, but I don't know, it kind of seems like it could fall under that.
It could, but because of relevant factors, yeah, okay, because of relevant factors. So when I see number 2, I think immediately I'm using a test with someone whose demographics does not match the normative sample, right? So I'm trying to use a test that's never been validated for,
Yeah,
right?
Yeah.
But you're right. And other pertinent factors.
Rick,
Yes.
this is a matter of thought for folks who are in teaching. I really wish that we had spent a little bit of time on number 6, because that has become one of my favorite pieces of text within the code. It gets me out of so many things, especially when attorneys show up with subpoenas for data.
Yeah.
I now go right to this and quote this statute and say, it would be against the law for me to do what you're asking me to do. It's been wonderful.
Yeah. Well, this one shows up a lot too. In our clinic, we get a fair number of college students and young adults who are needing accommodations for like not national board tests, but and now my jet lag is kicking in. Words are not coming to my frontal lobes, but for college board exams, that's what I'm trying to say. And so if they need some extra time let's say on the MCAT or the LSAT, those college boards will come and say, we need the raw data. And then the question is, are they qualified by virtue of their training to use those raw data? And that's been there's been some amount of debate in our clinic about whether such boards are qualified to use those raw data instead of the standardized scores.
What we do as a workaround is we tell them it's against the law for me to do what you want to do. However, if you want to do this, let me tell you how you do it. You need to identify a PhD level psychologist who will become the bearer of record, and I can transfer to them, but then they take on the legal liability of using that data properly.
Yeah, that's a good plan. So one thing to think about, given that we had been specifically kind of tasked with the question of electronic assessments, would be to have an item using assessment instruments or procedures that are inconsistent with the manufacturer's recommended administration, or with the validated administration procedures. That might be better, actually, the validated assessment procedures. And that would be fairly broad. But again, I think that sometimes broad is better here.
Right?
But that'll be something else we can maybe put some draft language together and think about that. Okay, our goal was to get to J. Or is there any other items in J that we wanted to talk about? Okay, well, then I'm going to go ahead and move us along and call us at the end of our continued discussion on unprofessional conduct regulations until next time, which we will get to the stirring conclusion of these. And then when we hopefully have a quorum, come back to a couple of those items, and I'll find the telehealth guidelines, and David will distribute those for us. Is that okay? Are we good?
Right.
Okay. Item Roman numeral 6 on the agenda is new business, and that was comments on the ASPPB's draft resource on regulation of practicum experiences for licensure. So David provided me it, and I guess we all had got that in the materials on Monday. It seems like this is the most applicable for people who are not in an APA accredited program who are seeking licensure, unless ASPPB is wanting to get into the game of regulating accredited programs, which I don't think they are. So is that a fair assessment, David, of the situation?
Yeah, I think so. ASPPB does put out certain best practice type documents, and that they design some documents that they would put out there to be used as suggestions or guides for jurisdictions when they're working on different statutes or regulations or changes to different things. So I saw this was made available and it was open for public comment. And so I thought some of you might have an interest in reviewing this and providing some feedback. If you do have comments, I'm happy to forward them back to ASPPB. But since this just occurred and it was open, I wanted to give you all the opportunity to review it. And if you have thoughts, just feel free to let me know.
Good.
Yeah, some of the associations have had a focus on listening to jurisdictions and trying to provide more helpful resources. And one of the things that I'm working on personally is trying to dig a little bit deeper into some of the available resources that are out there. So the ones that are timely, that are open for comment, I'm kind of focusing on first. And then I'm trying to dig back into the back catalog of some of the past documents that they've been working on to see if some of those might be helpful for us here too.
Okay. How does, if we're thinking about scheduling next time around, how does Tuesday, August 9th look for those of us who are here?
I'm good.
Rodney, you're looking like you're not good with that date. You're muted right now.
It's not that I'm not for it. I'm just frantically trying to get to my schedule.
Ah, I see.
That's what's going on.
On that note, though, I do wonder, because my workload has increased quite a bit. And so what's the procedure to submit resignation?
If you wanted to choose to do that, you could just send me a message. So that is an option, but there's really not a formal process for that.
Okay.
I'm okay with August 9th.
Well, given that there's only, less than a quorum of us, maybe we should just do, David, would you mind just doing a doodle poll?
Sure.
I mean, it sounds like it might be fine for the few of us that are here, but there's an awful lot of us that aren't. I don't see a conflict on that night for me.
Okay. Yeah, your committee usually meets the second Tuesday of the month at 6 p.m. But I can go ahead and put that out there with some additional options, and then just make sure that we have enough members to go ahead and have quorum for a meeting. So yeah,
That would be good.
Okay.
Okay. Well, with that, if anyone would like to make a motion to adjourn.
And actually, Rick, since we don't have quorum,
We can't even do that, can we? We just hang up. Is that what we do?
Yeah, the meeting can just end. But I appreciate all your hard work today. That discussion about the unprofessional conduct regulations, that was very helpful. And each one of the advisory committees is having a similar discussion. So I think as we work through these, we'll have a lot of good comments, and then we can kind of share some of the thoughts from the other advisory committees and share yours with those committees. So I really appreciate all the work that you guys are doing to go through those. So.
Okay. All right. Well, thank you all, and we'll see you in August.
Thank you.
Mhm.
Thank you, everyone.
Take care, everybody.